All right, moving along here, talking about equal rights. We are in the section on rights for homosexuals, and we're on slide number 33. Okay, so I talked about some of the challenges that happen when new groups get new rights, and I'm using the example here of homosexual rights. Okay, so one is a challenge to religious liberty or conscience. Okay, and again, when I'm talking about religious liberty, I'm not just talking about rights for religious people, rights for all folks, okay? Atheists, religious nuns, okay? Pure secularists, whatever. The concern is always when government can reach into your mind and tell you what to believe, that's problematic. Okay, that's the concern, and that was again a very real concern of the founders. So we're on slide number 33. Okay, the second concern is again, some of these are constitutional concerns. The challenge to morality posed by the expanded definition of liberty. Okay, in the case of Lawrence versus Texas. Lawrence versus Texas was a case again where a gay couple was caught in the act by police, violative of the Texas state law. And they protested, went to the Supreme Court. The Supreme Court sided in their favor, okay, and it struck down all laws basically prohibiting homosexuality. And a big part of the prohibition of homosexuality in many of the states that still had those laws was a moral concern. Okay, in other words, it wasn't just something where you're trying to be discriminatory against somebody because of color or anything like that. There were actual, moral concerns. And so basically what the court did in striking that down, and I'll show you the argument here, is it basically said morality doesn't matter in this country anymore, okay, generally speaking. They directed it against the laws, the moral concerns against homosexuality, okay? But basically it threw up there, hey, morality doesn't matter in a number of areas. So this is the dissent in Lawrence versus Texas from Antonin Scalia. He said this: the Texas statute, again, the Texas statute at the time criminalized homosexual behavior. The Texas statute undoubtedly imposes constraints on liberty. So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours a week in a bakery. But there is no right to liberty under the Due Process Clause, though today's opinion repeatedly makes that claim. So what's he saying? He's saying, listen, there are moral concerns about prostitution, okay? It's morally problematic. There's moral concerns about using heroin or any kind of drug that would harm a human being. And so his argument is, listen, if morals don't matter anymore, now we're going to be in a world of hurt as a society because you've just opened the floodgates of legitimizing a lot of activities that are harmful for human beings. He goes on to say in slide number 34, okay, the Texas statute undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable. The same interest furthered by criminal statutes against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. He says this effectively decrees the ends of all moral legislation. If, as the court asserts, the promotion of majoritarian sexual majority is not even a legitimate state interest, none of the above mentioned laws can survive rational basis review. Okay, remember we talked about reasonable basis, the reasonable basis test, another name for that is the rational basis test, is that there's a rational basis among the states for making fornication, okay, bigamy, adultery, adult incest, bestiality, and obscenity. There's a rational basis for preventing that spread throughout a community. That's why you get laws prohibiting it, okay? And basically what Scalia is saying is if you take the logic of the Lawrence versus Texas decision, which says morals don't matter as it applies to homosexuality, so laws based on morality don't matter. He said if you go in that direction, okay, no law that is created because of the moral concerns that a group of people have okay, for a particular practice, basically, you've just basically eliminated any legislation that's prohibiting things like gambling, or prohibiting things like the legalization of marijuana, or prohibiting things like prostitution, and on and on and on down the line. Again, an interesting argument. And the concern is that when you go in this way, okay, you're removing this concern, of morality in laws, okay? And so the concern is that, morality doesn't matter, okay? The third concern constitutionally is that there's challenges to democracy, okay, as a result of an expanded, I'm sorry, forgive me, I looked at the wrong slide. There's challenges to democracy as a result of Obergefell and similar social issues, okay? So, the concern is that if the court starts making these decisions, okay, what's going to happen is the ability of local communities to govern themselves. Okay, remember, one of the fundamental aspects of America is self-government. If local communities, if states cannot make decisions on these issues by themselves, we have punted to an unelected group of lawyers, 9 of them on the Supreme Court, 5 of which make the decision, 5-4, right? You're going to get your decision. And when that happens, you're saying that basically the rulers of the American people is not themselves, through their elected representatives, through democracy and protest and whatever, loud voices, right, to get your views across. We no longer have that. We have something called an oligarchy. We have something called the rule of a few who are fortunately situated on the court that are making decisions for us. So basically it removes it prevents us from having a voice, right? Because now representative democracy doesn't matter, only what the court decides. Okay, so again, let's look at the dissent in Obergefell of Antonin Scalia. Again, I want you to hear this argument, okay, in real time. So he says, he says this, and he dissented in the Obergefell decision that legalized homosexuality, or homosexual marriage, rather. It is not of special importance to me what the law says about marriage. It is of overwhelming importance, however, who it is that rules me. Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension, in fact, and the furthest extension one can imagine of the court's claimed power to create liberties that the Constitution and the amendments neglect to mention. Okay, so what he's saying is, if the Constitution and the amendments don't mention the liberty of homosexuals to marriage, it is not meant to be done at the Supreme Court level. It was meant to be done at the local level, through the states, through their elected representatives, through the give and take and arguments of its people, okay, making their case, and then making decisions that reflect the will of the people, in this case, in the 50 different states. Okay, that's what he's arguing there, okay? In other words, if the liberty of homosexual marriage is not in the Constitution, it was never meant for the Supreme Court and the federal government to weigh in on it. It was meant to be the states and the people, okay? And then he goes on to say in slide number 36, the practice of constitutional revision by an unelected committee of 9, always accompanied as it is today by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. Until the courts put a stop to it, public debate over same-sex marriage displayed American democracy at its best. Individuals on both sides of the issue passionately but respectfully attempted to persuade their fellow citizens to accept their views. And then going to the next slide here, that would be slide number 37. Again, he's arguing that when the court goes in the direction of making these kinds of decisions for homosexual rights or a lot of other social issue rights, it robs the people of being able to have a voice themselves. Americans considered the arguments and put the question to a vote. The electorates of 11 states, either directly or through their representatives, chose to expand the traditional definition of marriage. Many more decided not to. Win or lose, advocates for both sides continued pressing their case, secure in the knowledge that an electoral loss can be negated by a later electoral win. That is exactly how our system of government is supposed to work. And to allow the policy question of same-sex marriage to be considered and resolved by a select, patrician, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation. No social transformation without representation. Okay, so if you capture that argument, he's saying, listen, we can make changes like this. We can go the route of gay marriage, but we can't do it by sidestepping the electorate of the American people. Okay, that is not how our system of government was created to work. If you want that to happen, get legislation at the state level, or get legislation at the national level, or if you prefer, get it through an amendment, okay? Is that gonna take more time? Yeah. Is it gonna take more work? Yeah. Is it gonna take more sweat and argument and persuasion among the American people? Yes. That's how the founders set this up. They did not want massive social transformation that was disruptive in the case of gay marriage unless the American people consented to it. Remember, government derives its just powers from the consent of the governed. Okay, when the court makes these types of decisions, the American people have not consented. The court has decided for them. Okay, so again, take a look at these. I think they're interesting arguments because they're not going away, and these concerns are not going away as we move forward as a country. Okay, I'm going to stop there.